Hello. I'd like to call our meeting to order. My name is Randall Kennedy, and let me just say a bit about our session here. I thought it'd be a good idea periodically to talk about outstanding lawyers, particularly those who've had a strong connection with this law school. So a month ago, we had a session on Charles Hamilton Houston, and it was an interesting session. And tonight's session is on Thurgood Marshall, the Charles Hamilton Houston's most famous protege, and a person who's had a big effect on this school, at least in part. He's had a big effect on all law schools, but in the United States, but particularly at this law school, because so many people who clerked for him have become members of the faculty of this law school. I'd say certainly in the last decade, there have been more people who clerked for Thurgood Marshall that have been on this faculty than any other justice. I had the good fortune of clerking for Thurgood Marshall in the October term 1983. And it was one of the great privileges of my life. I had heard a lot about Thurgood Marshall before I worked for him, but it was great working for him, and I've had a deep interest in his life and his career in the years since. I'm going to speak a little bit about Thurgood Marshall's career, and then I'm going to raise some questions, and then I'm going to subside, and we're going to hear some reactions from Professor Terry Fisher. I met Terry Fisher in October term 1983 because he clerked for Thurgood Marshall that year as well, as did another of our colleagues. Howell Jackson was another Marshall clerk that year. Before I go on to give my little spiel about Justice Marshall, and we want to talk, but we want this to be free form, and we want there to be question and answer and discussion. So I'm not going to lecture for too long, but before I do, I want to send a shout out because I mentioned that I thought it would just be a good thing to have sessions where people could talk. And it would be fairly open, and we could take things in a variety of directions. And I mentioned this to the Dean of Students, and the Dean of Students thought, hey, that's a good idea, and is there anything I can do to help? And the Dean of Students has been very helpful in facilitating this meeting. I mentioned it to word got out to the Charles Hamilton Houston Institute. Charles Hamilton Houston Institute, again, no hesitation, let's do it. Let's do whatever needs to be done to get a room, to publicize things. As well, the legal history program, similarly. Similarly encouraging, similarly helpful. And I think I'm very pleased about that and very grateful for that support. So, let me just say a few things about Thurgood Marshall. Justice Marshall lived a nice long life. He was born in 1908 in Baltimore, Maryland. He lived from 1908 until 1993. The Baltimore, Maryland that he grew up in was a thoroughly segregated Baltimore. And it was a thoroughly segregated Baltimore that stayed on his mind throughout his life. One story that I heard on a couple of occasions had to do with the practical effects of Jim Crow segregation, Jim Crow racial exclusion. He told this story about going downtown shopping and how he goes downtown and he shops and he's on his way home and he needs to go to the bathroom. But there's no place where he can go to the bathroom. And so he hurries home and is, really trying to make it, but doesn't quite make it. And he urinates on himself right in front of his home. Now, he was a youngster when this happened. And like I said, I clerked for him in 1983, so you can do the math. This is a person who's grown up, who's had an extraordinary life. But he talked about that story. And when he would talk about it, you could tell that it still had its sting. It still meant something. It was a very bitter memory about the social conditions that he faced as a young person. He grows up in Baltimore, Maryland. His parents were part of the, I'd say the upper rungs of the black working class. His mother taught school from time to time. His father was the chief steward at a fancy country club, and sometimes he also worked on the railroads as a porter. They were well off enough to send Thurgood Marshall and his brother, he had a brother, they went to Lincoln University. In Thurgood Marshall's class at Lincoln University is a historically black university in Pennsylvania. Langston Hughes was in his class, and Cab Calloway was in his class. And he was very proud of his class at Lincoln University. He goes to Lincoln University. After Lincoln University, he decides that he wants to go to law school. Now, it would have made perfect sense for him to have gone to the University of Maryland Law School. It would be right there in Baltimore. It's where his parents are. It wouldn't have been a long trip. It would have been very convenient. But when he went to law school, the University of Maryland Law School was closed to black people. So he didn't go to the University of Maryland Law School. Instead, he had to take a train every day to Washington, D.C., where he went to the Howard University Law School. Now, life being the way life is, this was a paradoxical thing, an ironic thing, because actually, when he went to the Howard University Law School, he fell under the sway of a quite extraordinary person. He got a wonderful legal education, and he also developed contacts that were very useful for the rest of his life. He fell under the sway of Charles Hamilton Houston, who at that point was trying to make Howard Law School into a hothouse of legal talent. He wanted to create a cadre of lawyers who could attack racial injustice in the United States, and Thurgood Marshall was part of that. He goes to Howard University Law School. He does very well. Marshall was always very proud that he graduated. He was the number 1 student. I heard about that many times. He was the number 1 student. And and people would defer to that. And that was part of his calling card. He goes to Howard University Law School. When he leaves Howard University Law School in his 3rd year, he was offered a fellowship to come here by Dean Pound. And Justice Marshall, Thurgood Marshall, actually wanted to do it. He thought this would be a wonderful opportunity, but he did not. He did not because by that time he'd gotten married, and he needed money. And he did not, he just didn't, he just thought, I can't do it. It'd be a nice opportunity, but I can't, so he didn't. He goes back to Baltimore and just hangs out a shingle. He becomes a lawyer. He represents anybody who'll have him tell you the truth. He represents people in tort actions, contract actions, divorces, will settlements. He represents a laundry. He represents the Afro-American newspaper that became one of his most important clients. He also gets involved in representation of people charged with various sorts of crime. He has just an all-purpose practice. He doesn't make enough money to be. He has to supplement his his income as a lawyer by doing other things. He serves for many months as a file clerk. He does various things to make ends meet. In this period, one of the most important things that happens to him is that he learns about a fella by the name of Donald Murray, who had just come back to Baltimore from college and is thinking about going to law school. And somebody says to Donald Murray, well, it'd be good if you could go to the University of Maryland, but the University of Maryland is closed to black people. And Donald Murray says, yeah, I should do something about that. That's not right. Maybe I should, maybe I should sue. And Marshall hears about this. And Marshall, along with Charles Hamilton Houston, they offer their services. But Marshall is the chief lawyer. Marshall is his chief lawyer. And Marshall sues on behalf of Donald Murray. At that point, Maryland did what many jurisdictions did. They said to black people, listen, if you want to be a lawyer, here's what we'll do. There are not enough black people who want to become lawyers for us to create a law school for black people. And we're certainly not going to have black people in the white school. So what we'll do is we'll pay you to go out of state. And Murray says, nah, I don't like that idea. And so Marshall sues. And lo and behold, they win. This was Marshall's first victory as a civil rights advocate. And it was a sweet victory indeed for him. He had not been able to go, remember, to the University of Maryland Law School. But he brings the case. He says, listen, separate but equal. Separate but equal. You can have separate, but where's the equal? And the judge says, you're right, and orders the University of Maryland Law School to allow Donald Murray in. By the way, Donald Murray goes, he graduates, he becomes a civil rights lawyer too. During this period, Marshall is working with the National Association for the Advancement of Colored People. He's working on various cases with Charles Hamilton Houston. Houston goes to New York to spend all of his time working for the NAACP on its legal work. And after a period of time, he calls me, he gets in touch with Marshall, and he says, why don't you come up here with me? Why don't you, you're a good lawyer, you're interested in this civil rights stuff, why don't you devote yourself to it? And Marshall does. Marshall goes to New York, and after 2 years, Charles Hamilton Houston says, I want to go back to Washington to start up, I'm connected with Howard University Law School, as you know, and I have a law firm of my own that I have with my father. Why don't you just stay in New York and take my place as the chief lawyer for the NAACP? And that's what Marshall does, and that's what he does for the next 2 decades. And during those next 2 decades, he is involved in practically any important legal case involving race relations in the United States. Now, he's probably most well known, certainly in the law school world, he's most well known for his appellate advocacy. I once asked him which Supreme Court case of which Supreme Court case was he most proud? The cases that he argued, which is the one that meant the most to him? I thought for sure he was going to say Brown versus Board of Education. And I just thought that, I was just asking the question frankly, just to talk. He did not say Brown versus Board. He said, no, the case that meant the most, he said, the case that meant the most to me as an appellate advocate was a case called Smith versus Allwright. 1944, it was the case in which the Supreme Court of the United States struck down the white primary. In Texas in 1944, only white people were allowed to participate in Democratic Party primaries. That was very important because in Texas, it was a one-party state. Whoever won the primary, the Democratic primary, that person was going to be elected governor, that person was going to be elected senator. That was all she wrote. And so if black people couldn't participate in the Democratic primary, they were essentially disenfranchised. Well, Marshall got the Supreme Court in 1944 to strike down the white primary. And he said that for him was the appellate case of which he was most important. He went on to say, that, however, to me in any event, that actually it was not his work as an appellate lawyer that most satisfied him or that brought the most gratification. He said the cases that brought actually the most gratification were the cases in which he served as a trial attorney arguing before a jury. He thought that really played to his strength, speaking to a jury. He did the Supreme Court stuff, but that's not where he thought, his strength was. Now, of course, he argued a whole slew of Supreme Court cases, Smith versus Allwright, Brown versus Board of Education, restrictive covenant case, Cooper versus Aaron. One could go on and on and on. In any particular, school cases, jury discrimination cases, you name it. He has a long career as a civil rights advocate. That ends in 1961. In 1961, John F. Kennedy nominated Thurgood Marshall to become a member of the United States Court of Appeals for the Second Circuit. And Marshall, after a tough confirmation struggle, takes his seat. And for a number of years, he sits on the Second Circuit. Then in 1965, Lyndon Johnson says to Thurgood Marshall, hey, listen, I'd like for you to become Solicitor General of the United States. And Thurgood Marshall leaves his position on the Court of Appeals and becomes the nation's first black Solicitor General. He's Solicitor General from 1965 to 1967. In 1967, Lyndon Johnson nominates him to the United States Supreme Court, and after another bruising confirmation battle, he takes a seat on the Supreme Court, and he occupies his seat on the Supreme Court from 1967 until 1991. Now, just a couple more things about Justice Marshall, and now I'm going to set forth a couple of questions and hear from Terry. For me, one of the reasons why I like thinking about and reading about and talking about Thurgood Marshall is because actually just talking about him makes me think about another man who's been very important in my life, my father. I revere my father just like I revere Thurgood Marshall. And my father used to talk about Thurgood Marshall a lot. I grew up in a household where Thurgood Marshall's name was mentioned all the time. In fact, Thurgood Marshall or Mr. Civil Rights. And I heard about Thurgood Marshall a lot. There was one case in particular that my father talked about. It was a case in which Thurgood Marshall argued before a panel in Columbia, South Carolina, in 1948, It was a case called Rice versus Elmore. And it too was a white primary case. Again, to show the situation that he confronted, when the Supreme Court of the United States struck down the white primary in Texas, the governor of South Carolina, Olin Johnston, convened a special session of the South Carolina legislature in which he said, listen, the Supreme Court has just struck down the white primary in Texas, saying that Texas law was implicated. And because Texas law was implicated, that triggered the protections of the 14th Amendment. So what I want you to do, legislature, said Governor Olin Johnston, I want you to strip from South Carolina law all references to the primary. So we're going to get rid of all laws having to do with the primary, all of them. Then the primary will be totally private. The Democratic Party will be just a private party. The Democratic Party can say what it wants, free of federal constitutional intervention. And that's what they did. And there was a guy, and I'm from Columbia, South Carolina. There was a businessman in Columbia, South Carolina. His name was George Elmore. He owned a little grocery store. He owned a little grocery store not far from my grandmother's house. George Elmore sued. He said, I want to vote in the Democratic Party primary. And they said, no, you can't vote. He said, okay, fine, I'm suing. And his lawyer, he has several lawyers, but one of his lawyers was Thurgood Marshall. And my father used to talk about how he and a buddy heard about the argument, and they went to see the argument. Now, my father worked in the post office. He didn't know about this law stuff. The issue there was, it was state action. That was the issue. And everybody was yakking about state action. That's not what my father talked about. What my father talked about was going to see Thurgood Marshall, talked about just how good he looked, how he sounded, how handsome he was. He talked about the respect that he commanded in the courtroom. And the thing that stood out the most, and again, this will show you this situation that he faced. The judges called Thurgood Marshall Mr. Marshall. That was big. Decades later, that was big. Because in those days, I said this was 1948, Columbia, South Carolina. Under the etiquette of Jim Crow, black men were not called Mr. If you were a black physician, you might be called doctor. If you were a black minister, you'd be called reverend by the white folks. Mr., no, that was out. And so for these judges to call Thurgood Marshall Mr. Marshall, and for everybody, at least in my father's perception, and I think it was actually an accurate perception, his perception was that everybody in the courtroom viewed Thurgood Marshall as a very special person. That actually he was the biggest person in the courtroom and really an inspirational figure. And he was inspirational. I remember other people, in dinners and lunches and older folks talking. If there was a problem somewhere, hold on, Thurgood's coming. And he was that inspirational figure. And that's one of the reasons why, I was just so privileged to be able to work for him. I'm going to say one more thing, and then I'm going to set forth my questions. So I read, anytime something comes out about Thurgood Marshall, I read about it. And a couple of years ago, I came across something that I thought was really special. There's a man by the name of Michael Long, who puts together books of correspondence. So he has a book, I think, of Bayard Rustin's correspondence, but he put together a book of correspondence. He went to the Library of Congress and some other places and looked for letters that Thurgood Marshall had written to people or that people had written to Thurgood Marshall. And he puts together this book of correspondence, which really does show a part of Thurgood Marshall's career. It was news to me, and it showed aspects of Marshall's personality that I had not seen before. Marshall went all over the United States, sometimes in very dangerous places, representing people, arguing at every level of court. But that's not all he did. So after, arguing cases, what else did he do? He did all sorts of things. He would, in the middle of World War II, he went to Detroit after the Detroit riots and wrote up a report about that. He went to Korea to look into reports about black soldiers being mistreated. I mean, he was everywhere. But in addition to all of that, what this guy Michael Long showed in his collection of correspondence, Thurgood Marshall was constantly writing letters. Late at night, he was constantly writing letters. So I'm going to share with you a couple of the letters that he wrote. Some people wrote to Thurgood Marshall about a magazine in Michigan which published an item in an advice column that suggested a ruse by which motel proprietors could exclude black travelers. Now, Michigan had a law that prohibited this. They had a law prohibiting racial discrimination in places of public accommodation, a state law. But this was an advice column saying how you could get around that. Thurgood Marshall writes a letter to the editor of the magazine and says, you ought not be doing this. He complains about it. And he urges that the advice be retracted. That's exactly what the editor of the magazine does. He retracts it. A bit later, someone sends to Thurgood Marshall a candy wrapper. The candy wrapper had on the cover something about pickaninnies. And it had a cartoon of a little black girl with her hair sort of standing on edge. The imagery of the unkempt, raggedy black child. And she was supposed to be, an object of humor. Thurgood Marshall writes the chief executive officer of the candy company and says, we don't appreciate this, and we want you to do something about it. And the CEO writes him back and says, well, we didn't mean any harm by it. We thought it'd be sort of funny. Marshall writes him back and says, well, no, we don't think it's funny. We think that this is part of the, derogatory imagery that helps nurture racism in our society. And, you oughtn't be party to this. They withdraw that candy bar. They stop. Let me give you a third example. Third example is the most poignant. Marshall represents a kid in Florida who is involved in a shooting. And he's charged with murder, and he's convicted, though at trial it becomes very clear that the two black youngsters who were convicted of murder really do have a very good claim of self-defense. But the prosecution has prosecuted them for murder. It'd be loss of face for the prosecution to back off. So they don't back off. And they get the murder conviction, and they get a death sentence. Marshall tries to, he appeals, he loses. Then he goes and makes an appeal to the governor of the state. And the governor of the state says, under different circumstances, I might commute the sentence, but I don't think my people are going to go for it. This kid is executed. And Marshall, after the execution, writes a letter of condolence to this kid's mother. And it's an absolutely extraordinary letter. And one of the things that, sort of struck me, because Marshall was a fairly gruff person. He was a tough, gruff person. He writes this tender letter in which he says, I want you to know that we at the NAACP did everything we could to save your boy's life. And I want you to know that I know that you did everything you could to save your boy's life. And what I hope is that going forward, there will not be occasions for letters like this. I mean, everything that he's doing, and he's writing these letters, just letter after letter after letter. That's Mr. Civil Rights. All right. I have, much of what's been written about Thurgood Marshall is very complimentary, as it should be, as far as I'm concerned. I think he's one of the great people in American history. I think there's a very strong argument that could be made that he is the greatest lawyer in the history of the United States. I'd be happy to take on that side, because he certainly gave anyone making that argument a whole lot of ammunition with which to make that argument. I do think, though, that because he was great, we ought to be fully willing to ask questions about him and to probe and to second guess and to, argue. And I think that has not been done. For various reasons, I don't think it's been done, but I think it ought to be done. And here are a couple of questions that I have. One of the most controversial things that happened during Thurgood Marshall's time as a civil rights advocate had to do with his choice of a successor to head the NAACP Legal Defense Fund. So he was the boss of the NAACP Legal Defense Fund. He was the unquestioned boss. So when he steps down to become a Court of Appeals judge, the question was, who did he want to succeed him? There were two people who were sort of really who people sort of viewed as the most likely successors. One person was a man by the name of Robert Carter. Robert Carter became a judge. He became a very distinguished man. He was the second in command at the NAACP for many years among the lawyers. He argued Brown versus Board of Education. He had a very distinguished career. But he also had a rather tense relationship with Thurgood Marshall. He was a little bit younger than Marshall. He had a very different personality than Marshall. Marshall was a hard-drinking, sort of uninhibited kind of guy who could get along with everybody, and I mean everybody. Robert Carter was a very buttoned down, sort of inhibited, very careful sort of person. So they had sort of a tense relationship. Robert Carter was black. The other person who people thought might be a successor would be Jack Greenberg. Jack Greenberg worked for Thurgood Marshall, started right out of law school, and was a very distinguished person in his own right. Extraordinary career. When Jack Greenberg would travel with his black associates with the NAACP down south, he stayed with them. He was, he was as much in the mouth of the lion as anybody. He gave 1,000%. There was no one had any doubts about that. There was the following question, though, and I must say it's changed. My thinking about this has changed over time. There were people at the time in 1961 who thought the following. Both of these people are wonderful attorneys. Both of them have paid their dues. Both of them would be fully capable of steering the legal defense fund in a good direction. There were people who said, under the circumstances, given the fact that there's still relatively few black lawyers, even fewer who are in positions of authority, given the special meaning of black lawyers, particularly in the South. Remember what I said about my father just going to see Thurgood Marshall argue a case? That was true in the 1960s as well. I mean, it was big, when these lawyers, NAACP lawyers would go down south and argue a case, people would come from miles around to see a black lawyer argue a case. That was a big deal. And there were people who thought, inasmuch as that's the case, it would be good if Robert Carter, a black lawyer, was to succeed Thurgood Marshall. Marshall didn't see it that way. He tapped Jack Greenberg. And for a short period, didn't last long, but it was muted. It was a muted controversy. But it did engender bitterness over the years. And in the biographies of Marshall, in the commentary of Marshall, people will mention this, but very quickly, it seems to me that it needs to be opened up and examined and thoroughly discussed. Second issue. There was a time when Marshall was, in the 1950s, when Marshall was a civil rights advocate. In the 1950s, there's the civil rights movement. That's taking up a lot of time in American domestic political life. There's also a Red Scare, right? There's also the Cold War and a Red Scare. And the Federal Bureau of Investigation is investigating lots of people, alleging that people are, communists. If you're dissenting, then maybe you're a communist. Well, biographers of Thurgood Marshall have looked and have issued Freedom of Information Act requests. And I think it was Juan Williams' biography in which this came out the most. And, Thurgood Marshall from time to time would talk with FBI people. The FBI people would say, is so-and-so a communist, is so-and-so a communist? And he would talk with them. Some people are very critical of Marshall for even talking at all with the FBI people. Other people defend Marshall on the grounds that, well, first of all, he wasn't telling the FBI anything the FBI didn't know. And second of all, the FBI was a very important agency, and he thought that for the purpose of advancing the goals of the NAACP, it was important to be on at least speaking terms with J. Edgar Hoover and the Federal Bureau of Investigation. But this too is a subject, it seems to me, that needs to be, people need to look at a bit more. Finally, people talk about, there's this, I think that especially partisans of Thurgood Marshall get a little bit defensive when the question arises, how good a justice was Thurgood Marshall? I mean, I've been in lots of settings where people will say, you know, the question of how good a justice was Thurgood Marshall, and the friends of Thurgood Marshall will get all uptight and will say, and we'll try to shift the conversation to his years as, you know, an advocate. There's no question that he was a great advocate. The question on the floor was, you know, well, how was he as a justice? Me, I have no problem. I think he was a wonderful justice. I think on the issues that mattered most, if one thinks about the nature of, you know, what is going to be the nature of liberty in the United States? What is going to be the nature of equality in the United States? What rulings will best advance the status of women, the status of gay, lesbian people, the status of anybody, frankly, who's been marginalized, oppressed, mistreated in American life? What votes, what theories presented in the Supreme Court of the United States have been good with respect to the people on the outs in our society? On each and every one of those, Thurgood Marshall in the forefront. Organized labor, the rights of the incarcerated, abolition of the death penalty, on down the line in the front ranks of progress. So for me, no problem. A superior Supreme Court justice who, from, you know, in my view, there's some people, they have, you know, law professors periodically have ranks of great justices. They do, they have ranks of great justices. And, Marshall, great justice. Well, he helped, you know, dispossess the Native Americans, and he helped, you know, solidify slavery. Oh, but he was a great justice. Joseph Story, we passed the, you know, Joseph Story coming in to the library every day, right there, you know, right across over there. You know, Prigg versus Pennsylvania, yeah. Tawney is viewed as a great justice. Tawney is viewed as a great justice. You know, Dred Scott, well, everybody has their bad day. Thurgood Marshall does not have, you know, I don't think he has to be ashamed, morally ashamed about judgments he's made. Something that cannot be said of Oliver Wendell Holmes, Brandeis, go down the list. So as far as I'm concerned, I have no problem with saying that I think that Justice Marshall was a superior justice. And I don't think, but we can talk about it. Any event, that's enough for now. Terry, it's yours. Thank you.
I'll be quick because I'll bet people want to ask Randy questions. As Randy indicates, we were law clerks, same year. Unlike him, I knew very little about Thurgood Marshall before I began working for him. I knew only his opinions, some of his opinions, and what I'd read in this muckraking book called The Brethren, which is about Supreme Court justices. That was it. But I grew during the year that we were working together to admire him a great deal, and that admiration has only grown over the years. Let me tell one anecdote and then say a few words about the open questions that Randy's identified. So the one anecdote is I had 2 kids when I was clerking for him, and my older daughter was 3.5. And he was very demanding. And so we worked really long hours, and this is hard with little kids. So my daughter was curious, you know, what I was doing so many hours away. And one day the business wasn't quite as intense as usual, and I took her to work and took her into Marshall's inner office. So there was, the layout there was an outer office, which was where the secretaries operated, and then there was a room to the left where the clerks huddled. And there was a room to the right that was a conference room with a table. That was, of course, his conference room. And then there was an inner office beyond the conference room. That was his private space. So he encouraged me to bring my young daughter in. Now, as Randy indicates, he was a gruff man. He was also big. He was about 6'2", 6'3", he was a little overweight, and he was big. As my daughter enters the room with me, she's looking, Marshall's large, and she looks around the room, and she sees on a chair on the left-hand side a lion skin, complete with the full head of the lion. Now, where did this come from? Marshall helped draft the Kenyan Constitution, and this was one of the presents given to him, gratitude for his work there. My daughter didn't know that. She just knows there's this giant guy and this lion skin. So I, with some trepidation, because I knew I didn't want her to be upset, I handed her to him. She sat on his lap for a while. We had a conversation. And she sat on his lap just like that. She wasn't crying, but she was definitely, this is scary. And then I left and she went home. She still remembers that. It really figures prominently in her memory. A few years later, I was teaching here, and the other judge for whom I clerked, Harry Edwards, is also black. So my kids both had the impression as children that to be a judge in the United States, you have to be black. And Harry Edwards was coming to town, and we were doing something together academically, and I said, yeah, Judge Edwards is coming. And she's trying to remember who Edwards was. And you can't differentiate between them on the basis of race, so she says, is that the big judge or the little judge? He's the little judge. Something I definitely did not pass along to Harry Edwards. And answered a couple of, or to address briefly, some of the issues that Randy has raised. Anybody seen the movie came out last year about Marshall? Yeah. Okay. It's a good movie, but it's not an accurate depiction of Marshall. And one of the ways in which it's not an accurate depiction is he worked like crazy for his clients, and he would adopt whatever tactic was necessary to advance their interests, even if it meant suppressing his own pride and dignity. So he wasn't called Mr. Marshall by every judge he appeared before. He was treated rather badly in many courtrooms in the South, especially at the trial level and especially in criminal cases. one of the wonderful things of working for him is we heard a lot of stories of these things. And when it happened, he did not push back and demand recognition. He would assume whatever posture of obsequiousness was necessary to advance the position of his clients. It's one of the things I admired about him. And the hero in the movie does not do that. So it's a basic difference, character difference. This may help to explain his choice of Greenberg, that he was less concerned as a lawyer with the visibility of black lawyers as lawyers than he was of advancing the cause of the clients, whether it's an individual criminal defendant or people excluded from white primaries. So it would not surprise me, although I have zero direct evidence of this, that he was making a judgment as between these two successors on the basis of who he thought was going to be arguing more effectively on behalf of the clients, that pure and simple. Now, whether it makes sense in the long sweep of history to exclude the obviously important significance of advancing the careers of lawyers, all right, that's a complicated question, but I'm guessing now what he might have had in mind. Just one more thing, and I'm hoping other issues will come up in conversation. With respect to whether he was a great Supreme Court justice, yes, this for me is an easy issue. Definitely for the reasons Randy's indicated, but for another reason as well, which is that at the time that he was a justice, there were circulating in the academic space and on the judiciary lots of different theories about what responsible adjudication meant and what constitutional adjudication ought to mean in particular. They included originalism, various variants on fidelity, various forms of textualism, now prominent at this law school because of Dean Manning's support of them, and some more complicated theories, like the process theory of John Ely. A lot of them. What they had in common was either complete or partial suppression of the judge's belief concerning what a good society and a good life should be and how one could interpret the Constitution and other legal doctrines to advance it. He rejected all of those. He had a vision of what a decent society was like. It included the absence of racial discrimination, but it included a lot of other things like decent jobs, decent housing, access, effective access to education at the primary level, the secondary level, at the university level, freedom from fear, freedom to speak, freedom to gather. So it actually it's not a vision that in every context favored the outs. So he was, as he used to say, a man of the law, and that meant that he actually, during the heyday of the civil rights movement, didn't have a lot of patience for some of the extra-legal tactics employed by marchers. It was a complicated relationship with Martin Luther King. So it's not as though he was in every instance advancing the interests of the downtrodden, but he had a particular powerful, and in my view, admirable, substantive vision, and he adjusted his adjudication overtly to advance it. One of the reasons why he had such a tough time in his confirmation hearings is not just because he was black, but it's also because he didn't do what all other candidates in the 20th century do when they appear before the Senate and confirmation hearings, which is they say, I just followed the law. I'm like an umpire. I call the balls and strikes, And my personal views are irrelevant. They all say that. He did not. So I'm agreeing with Randy, but also suggesting one level of generalization, that he had, in my view, an honest and commendable constitutional theory and the courage to articulate it in an environment where it was uncongenial. Weirdly, now, such visions are being advanced more directly. They just happen to be the opposite of the vision that he had. But it is somewhat more common now for people to be overtly picked and defended on the basis of what they believe in than it was at the time. Anyway, there's much more to be said, but I think it's time for conversation.
Yeah.
Randy.
Well, we won't just. Comments, questions, objections? Yeah.
During the Charles Hamilton Newstead event, you talked a little bit about how you thought there's a contrast between Thurgood Marshall, whose economic thoughts and economic theory was basically there's a pie, and I'm not trying to change the flavor of the pie or throw out the pie. I just want us to be able to have a piece of the pie, versus the way Charles Hamilton Houston looked at it. Can you talk a little bit about how that, in your opinion, affected both maybe either his lawyering or how he was a judge, or just any general thoughts you have on that?
Yeah,
I found that interesting.
I think Marshall was, maybe there's some difference. My sense of Marshall was he was ideologically a liberal. He was not a revolutionary. He was perfectly willing to take sort of liberal precepts and sort of, he wanted to get rid of racism, he wanted to get rid of sexism. With respect to political economy, I think he was pretty willing to have a pyramidal society, but just, no invidious discriminations in it. So, I don't think he was not a socialist. Like I said, I think he was a straightforward liberal. One thing I want to pick up on, he definitely, and I think this was an important thing, he definitely was a person who was very willing to subordinate his own, status for the good of whatever project he was working on. In fact, one of the things that was so cool about him, here was this guy, he was a big shot. He was a justice of the Supreme Court. No presumption whatsoever. And that was part of his armament, though. I think that he was very used to people taking him lightly and for people underestimating him. And I think he would give people a lot of rope to use. One of my favorite, there was a case, there was a story about, he comes to the Supreme Court, he gets in an elevator, and he's just he's a large but sort of elderly black man in an elevator in a suit. Some tourists come in, and the tourists say, he's just standing there in the elevator, and they turn to him and they say, 5th floor or whatever it is. He doesn't say it, he just punches the button. And actually it was the library. He goes up to the library, the door's open. He didn't go up there very often. So when the library door opens, the librarian is right there, and the librarian says, "Oh, Justice Marshall, it's so great to see you." And of course the tourist's jaws drop, and they're trying to get themselves together to say something before they get themselves to say anything. The door's closed, and he just goes right back. But that's just and he liked to tell stories. You remember the story he tells about being, in the Deep South, And the sheriff comes to him, and the sheriff says, we don't allow black people to, be around here after dark. And, Marshall said, he had his Constitution in his back pocket. The sheriff was acting in a blatantly unconstitutional way, but did he pull out the Constitution and all that? No, he didn't. He kept the back pocket, he kept the Constitution in his back pocket, was hoping for the train to come, got on the train, lived to fight another day. And that's, and that's the way he was. He was, he was a very practical, pragmatic guy who, was willing to take a step sideways, a step backwards, in order to go forwards. Do you remember the story he told? He loved to tell this story about arguing with, how did he make it during the age of segregation? So I remember once late in the Supreme Court term asking, with one of these death penalty cases, and he was always in dissent. And I said, Judge, how do you always feel like, you're always in dissent? How does that feel? You're always losing. I mean, aren't you discouraged? And he said, no, I'm not discouraged. And then he says, you got to remember that for most of my time as a practicing lawyer, Plessy versus Ferguson was my affirmative case. And he told all these stories about how, you've got to get what you want in various ways. He talked about this case where he's called down to, I think it was in Louisiana. NAACP in Louisiana calls him down, and there they say, listen, we got a real problem on our hands. There's a white school for nurses, but there is no black school for our, for black people who want to be nurses. So Marshall writes a letter to the governor of the state, and the governor of the state, and he sort of says, we hope we can work this out. If we can't work this out, it's going to have to be litigation. And the governor of the state says, Mr. Marshall, I want to work out a deal with you. I will get you very quickly a school for black nurses. But you got to do it my way. I'll get you the school, but you got to do it my way. And I don't want to hear about litigation. Do we have a deal? Marshall says, yeah, we got a deal. Immediately, the governor of the state calls a press conference and says, we've got an emergency. We've got a dire situation in this state. We have a situation in which our white nurses, our white women nurses, are scrubbing the backs of these black veterans. We can't have that down here. I'm demanding an immediate, allocation of money for a black school. And of course, there is an immediate allocation of money. Marshall's view was, there's various ways of getting what you want. And that's the way he operated. Do you remember any? That's just the way he was. And
I agree with all that, but I disagree with one thing.
okay, please.
Yep. There are points at which commitment to liberalism, as you rightly identified, can be revolutionary. And I think the clearest example is the San Antonio School District case. Had he won, he was in dissent.
Right.
But had he won that case, it would have changed the way in which public schools are funded in the United States. It would require equalization of public schools. And it's one of the major ways in which inequality is perpetuated now is the fact of local funding for public schools, which means that poor towns get poor schools. Now, it's not uniform. There's higher funding for public schools in Boston, which are lower in quality than any suburban schools. So it's not a one-to-one match. But his commitment to this idea of equality, when it extended to education, would have made a big difference. The technical issues, remember that case, was whether slowed the continued trend toward economic inequality in this country.
I don't want to fight you too much. I do want to point out, though, that there are a number of states that have gone the way that Marshall wanted to go in that case. Question, how much of a difference has it made? I'm not sure it's made as much of a difference, unfortunately. And I think that the tendencies in our society that reinforce inequality are so tremendous that even had that case gone a different way, I'm not so sure it would have made that, as big a difference as you're saying. On the other hand, given where we are now, and by the way, that was a 5-4 case. Would things have been a lot better had he had more support? Yeah, I think things would have been a lot better. For one thing, had he had more support, our society would not be in the position of still engaging in government-sanctioned killings. I mean, that's just a very basic thing. I mean, one of the best things about Marshall, and one thing that has not been the case ever since he left the Supreme Court, there are no death penalty abolitionists on the Supreme Court. There has not been a death penalty abolitionist on the Supreme Court since Marshall left. That is to say, the way he was. I mean, they got a lot of people who vote against the death penalty, maybe time after time after time. But there's nobody on the Supreme Court who took the position that he took, that the death penalty was in all circumstances unconstitutional. And that's one of many things. So again, I don't want to belittle the reformist punch that was there with him. But, well, I'll leave it at that. Others? Yes, sir.
Excellent segue into my question. I have this mental kind of Hegelian kind of thing, the pendulum of history that goes back and forth. And one thing happens here, and then all of a sudden, you get Obama on this side, and all of a sudden it's Trump. And the question is about that sequence with Marshall, and then the next person that followed, Thomas. And I think you're one of the best persons I could ask you this question. What do you think about that? That we go from one person that is really on this side of, that issue, to another person who is just sitting there, basically, just not talking about what's happening in the world.
Well, I have a definite opinion on that, but I'll let Terry, you want to take a shot? Well, I mean, my view on that is one of the great tragedies. I can't imagine it's hard for me to conjure a more poignant trajectory than the move from Thurgood Marshall to Clarence Thomas. Along, by the way, a variety of dimensions. I'll talk to the ideological dimension in a minute, but just from a lawyer's point of view, we simply want to talk about, the mastery of, juridical craft. I mean, frankly, it's, Marshall was a very distinguished lawyer. He was a person who practiced law at every level. And there's nobody on the Supreme Court who's had a broader array of practice in the law. Private practice, lawyer with a cause, Solicitor General, Court of Appeals judge, Supreme Court justice. And I haven't exhausted it, but you see the point. Yeah. So there's that. And, and then Marshall's background, and, there's that, and then, of course, complete difference in sensibility and aim, and, from my ideological perspective, and, everybody has an ideological perspective. I have an ideological perspective. I'm a person on the left. And so, frankly, I view it as a tremendous tragedy. Now, it does raise another issue, by the way, with respect to Marshall. Marshall leaves the court in 1991 when he's in his early 80s. Question, is he subject to criticism for not having left the court at an earlier point? Marshall used to joke with the law clerks, saying, if I die, prop me up and just keep voting. And he used to, we used to laugh about that. Of course, that's not what happened. And I think, could it be said? A lot of this, because of the way the Supreme Court is structured, it's not, you can resign, you can retire, or you can die. It's not, it's a funny sort of structure. And the whole question of, when one chooses to step down is a very complicated thing. There's so many things we don't know. So, for instance, in thinking about this issue once, I looked into it a little bit. Thurgood Marshall had some heart problems during the administration of Jimmy Carter. In fact, he had such heart problems that there were some feelers that Carter, there were some Carter administration people who, gingerly, quietly, sort of felt Marshall out. And, you have to do this in a gingerly way, after all, because, you're talking about somebody's mortality, right? So Marshall basically, sort of rebuffed them. Question, would it have been a good thing for him to resign? Had he resigned, and again, life is just, like life is, the person who would have probably, if Marshall had resigned, the Solicitor General of the United States in the Carter administration was Wade, it'll come to me in a minute. Very distinguished Court of Appeals judge. He was the second black Solicitor General of the United States. And it probably would have been the case that he would have been chosen. So I looked at it, I said, well, that's interesting. The fact of the matter is, Wade McCree was his name. Wade McCree. Wade McCree, a few years later, passed away. Should he resign? You can't. These things are very difficult to tell, very, very hard to gain. But to go back to your question, I think it was a sad, evolution of the Supreme Court of the United States.
Couple things. On the other end, was there regret that he didn't stick it out longer for Clinton to be elected?
Yeah, 6 more months. It would have been that. That would have been that. But he was in very bad. I remember distinctly being at the law school and hearing that there was a press conference and the word was Thurgood Marshall was going to retire. And I remember people sort of trying to get to any television they could get to. And a reporter said to Marshall early on, what's wrong with you? And Marshall responded by saying, I'm falling apart. And he was. He was, when we worked for him, when we worked for him in 83, he retired in 91. When we worked for him, I had never been around anybody as old as that other than my grandfather. He was an elderly person. And, by 91, it was really at the end.
The other things are, you talked about the case in Unbosu, did he ever talk about which losses sort of stung the most? And then lastly, when I was a student here a couple decades ago, there was an event sort of celebrating his life, and his wife was there, and several people were there, and I was fortunate enough to meet Jessie Norman at that event, and I wondered if she had done a lot of work for
Who?
Jessie Norman, an opera singer.
I know nothing about that. No, it's an interesting thing. I don't ever recall them talking. It sort of fits with, I don't recall, I'm trying to think. I don't recall him expressing regrets or, talking about things that really stung. The one thing that I think he did talk about with tremendous regret and real feeling was the death of his wife, the death of his first wife, Buster. And she died, of all years, 1954, the year around her split education. But insofar as his legal career, he was a very, again, just like Terry said, just like Professor Fisher said, he was a very tough customer. So for instance, at the Supreme Court building, they have a portrait of him. I think the portrait really does misportray him. Because the portrait, he looks like a very genial, grandfatherly kind of person. Really the kind of person who's, handing out candy and stuff. That is not who he was. He was elderly, and he was a taskmaster who was, he was not playing around. He was not playing around. He did not. He told us. Remember, he told us early on, and for the first few weeks we worked for him, we didn't talk. I didn't talk to him. He'd come in every day. I'd nod, and he would just nod, and then go into his office. And then after we worked for him for a couple of weeks, he called us all together and basically read us. He told us what the rules of the road were, which were not many, but he had us to understand that the few rules were not to be messed with. And one was you cannot talk to reporters. If I even think that you would talk to a reporter, I'll fire you because of that book, because of the brethren. He was very hurt. It was very clear that law clerks, including his, had talked to Woodward and Percy, and that really hurt him. He didn't like that. He was a bear about things being on time. If you were ever late, even a little bit late, big problem. In fact, there weren't many problems because he told us, he said, listen, if I get mad at one of you, I'll be mad at all of you. And so we had a system where we looked over one another's shoulders so that to make sure that nobody got mad. Because we knew that if you got mad at one, we were all sunk. So we didn't, we ran a pretty tight ship, but he was a very tough guy. And one other thing, I'll say, there were a couple of occasions, because like I said, I hadn't been around anybody who's older. There were a few occasions on which I took him lightly, in which I thought, this guy isn't really, No, I did. There was one case in particular. It was the sleeping in the park case. It was the CC&D. It was a case that involved the question of whether the National Park Service could prohibit all sleeping in the park. They passed a rule because there was a guy who was a champion of the homeless, and he would have the homeless sleeping Mitch Snyder. And he would be having people sleeping all in Washington, D.C., all over the place, and to dramatize the plight of the homeless. So the National Park Service said, we're not going to allow anybody to sleep overnight in the national parks. This case comes to the Supreme Court of the United States. And Marshall writes the dissent. And it was one of my cases. Drafts the dissent. There was a law professor, who I admired and knew, and, who had written an article about this situation. And I thought, oh, Professor so-and-so will be so happy if, Marshall, has a footnote, which is cited, blah, blah, blah. So I dropped this footnote, cite the article. It's in the middle of a fairly lengthy dissent, the middle of it. I thought, there's no way that Marshall's going to be paying any attention to this. This will be nice, Professor so-and-so will be happy, and Marshall doesn't care. I turned that thing in. I remember distinctly. He had an inbox. I put the thing in the inbox. A couple of hours later, I see the thing in the outbox. I get the thing and I think everything's cool. I'm, looking through, nothing. That footnote, big red X. He was watching. And not often did I, only once or twice, but every time was caught up. And again, I think he knew people would take him lightly, and he'd give you just enough rope for you to have yourself. Otis, yes.
I wonder if Professor Fisher would be willing to expand on your comment about the relationship between Marshall and Martin. I think you said something about tension. I wasn't sure exactly what you said.
Go ahead.
Yeah, there was tension, because Marshall thought that King was a little bit of a grandstander and was circumventing the right path to securing reform, which was changing the law. And even more so, Jesse Jackson. Yeah. So they, I could give you examples, but I can't. Of circumstances in which it became evident. But the generalization is, yeah, he thought the cause of civil rights was best advanced by working more or less within the system and not by civil disobedience.
That seems to be something that happens in all movements.
Happens in what?
All movements, you have that kind of dichotomy.
Maybe that's right.
There was a generational aspect to it. I mean, King, I think Marshall felt, I remember when Marshall died at the Supreme Court, the day that Marshall died, the day after Marshall died, his body lay in state at the Supreme Court. And it was really so wonderful to go to the Supreme Court, and the line was so long that they kept extending the hours for viewing. And it went on and on and on and on. And I remember thinking, gosh, this is really, Marshall would have been surprised, because I think he felt that, people remembered King, people remembered, Birmingham, people remembered Selma, people remembered, what happened in the 60s. And I think that he felt that people forgot what had happened in the 40s, what had happened in the 30s. So, he had a long career. So, when you talk with him, he was talking about, Roy Wilkins and Walter White, and people who people had forgotten about. And I think that everybody wanted to talk about Martin Luther King, and in fact he really did bridle sometimes. So he talked about the time when you get in a you would get in a cab, and cab drivers would be giving Martin Luther King Jr. credit for things that the lawyers had had won. And his attitude was, hey, there are other people involved in this thing too. But there was a he was considerably older, and that was part of it.
question about, would you talk a little bit more about his time as a government lawyer during the early 60s when the civil rights movement was taking speed in the early 60s?
Well, the only time, he was only a government lawyer between 1965 and 1967, when he was the Solicitor General of the United States. And there was some real nice symbolism at the time when he was the Solicitor General. So, for instance, among the cases that he argued on behalf of the United States government, he argued, for instance, the case Price versus the United States. That was a case involving the murder of 3 civil rights workers, Goodman, Cheney, Schwerner. Some of you will remember that terrible killing in the summer of 1964. And of all people, it was Thurgood Marshall who argued the case at the Supreme Court, which enabled a prosecution of some of the murderers of those civil rights activists. It was during that period that he was the Solicitor General. During that period, he argued a number of important cases involving policing. And here, to pick up on a point that Terry made, Marshall, he was interested. He very much demanded that the government, governmental power not go beyond its bounds. Very, insistent on that. Very, appalled at, militantly hostile to any sort of, police brutality or anything like that. He also, however, was for, what he would view as, decent law and order. I mean, his son, one of his sons, became the head of, I think, the state troopers in Virginia, and he was very proud of that. And, he's a very practical guy. It's a big country, a lot of people. People, especially poor people, need protection. They need, good police protection. And he was very attuned to that. And, he was not sentimental. And sometimes, in fact, he could be, at least in my view, I was really surprised. Every year there would be a case in which there would be some person, very often, by the way, a prisoner, who would send the petition to the Supreme Court, and there'd be some procedural problem. It would be late. It had been filed late by, a day. And, the clerks, or some of his clerks were, come on, Justice Marshall, you're Mr. Equity. We know good and well that you're going to, want to give this guy a break. He was a stickler for rules. And one of the reasons why he was a stickler for rules is because he saw rules as something that would actually be a way of protection for the outs in society. So he could be actually very, very tough. And that's just the way he was. He came up the tough way. He came up in a very inhospitable, circumstances, and it should. Yes.
Okay, the question will be a bit long-winded, but there's a punchline, I'll get to it. So, with the explosion of this sort of, you raised Bayard Rustin at the very beginning, and so with the explosion of the sort of Dixiecrats in 62, 63-ish, you have folks like Rustin, Philip Randolph become firmly convinced of perhaps the necessity of repurposing the Democratic Party into a social-democratic party with like the realignment strategy, right? And sort of being able to call blacks, women, and also the working class, right? In this white working class, right, in the South. And so, of course, Marshall, right, goes in another direction, right? Perhaps I would, given how so many formative folks of his generation were politicizing a more socialist direction with the expulsion of the Dixiecrats at the outset of the 60s, how was Marshall in the other direction? Perhaps made even more convinced of his own liberalism contra that, or in distinction to that.
Marshall was, like I said, Marshall was fervently anti-communist throughout his life, fervently. And he was not as, he did not have as much of a social democratic impulse as, as some of the people that you mentioned. He was not as much of a social democrat, for instance, as Bayard Rustin. He was, as Professor Fisher indicated, a strong liberal. So, in American politics today, he'd be considerably over, strong liberal. He was fervently in favor of organized labor. And that was a thing with him. He definitely deeply believed in unionism. In fact, one of his most interesting cases, he had there were very few times when the NAACP criticized Justice Thurgood Marshall. But it did happen from time to time. And one of the times it happened was a case called Emporium Capwell. And Emporium Capwell had at its heart a conflict between, on the one hand, union solidarity and the idea that unions should speak with one voice on behalf of the workers, versus, on the other hand, the idea of black workers having their own independent voice. And there was Marshall wrote the opinion for the court in Emporium Capwell, arguing for worker solidarity, though union speaks for the workers. And there were a number of academics, for instance, Professor Gould at Stanford, and a number of people, the NAACP, very critical of Marshall on that, but, too bad that was his view. That was his view, and that was his view. In today's world, I think a place where this would come up would be, I bet, things like freedom of expression. Marshall was fervently libertarian with respect to freedom of expression stuff. He was against anything smacking of censorship, whether it had to do with pornography, whether it had to do with so-called hate speech, whether it had to do with anything. He was really, very, very, very committed to, open, let people speak, and that's just the way he was. I bet, today, it'd be interesting to see, vis-a-vis, others on the left end of the political spectrum who, I think would probably differ with them in that domain.
There was one of the controversial cases from the standpoint of some black critics at the time, illustrated that Lindmark Associates case involving signs, for sale signs, arose in the context of blockbusting, when a neighborhood would be having a few black homeowners come in, and realtors, unscrupulous realtors, would take advantage of the anxiety of the white residents concerning black infiltration by saying, the neighborhood's going colored, get out now while you can. And one of the tools to do that was to put signs of as many as possible in the neighborhood saying, for sale, so you have a sense of, I gotta put out more. And the town forbade the posting of these signs deliberately in order to retard blockbusting. And he said, no, violation of the First Amendment. And the practical effect was to accelerate blockbusting. I'm going to disagree. Well, I'm not sure it was a disagreement. I'm going to highlight one respect in which his particular brand of liberalism would put him well on the left of the political spectrum now, which is somehow or other, I'm not sure when this happened. You don't talk about the poor in American politics anymore. You talk about the middle class. So our most progressive live candidate in the Democratic Party now is Elizabeth Warren, and all the language is the middle class, and tacitly there's a gesture of genuine economic equality because she talks about access to the middle class, but in truth, she doesn't talk overtly about the poor, whereas Marshall always talked about the poor. That has just dropped out of the spectrum of what's considered plausible national politics now.
Thank you, Professor. I'm sorry it was a few minutes late, so if this was addressed in the remarks, forgive me, but much has been made in recent years of the relationship between Antonin Scalia and Ruth Bader Ginsburg, sort of this cross, I guess, political, friendship. And I was wondering in Justice Marshall's day if he had any sort of friends, on the right with whom he vehemently disagreed, either, another justice or somebody just who he got a kick out of that was on the other end of the political spectrum.
I was there for 1 year. The year I was there, one of the things that surprised me was actually how distant the justices were. Marshall would walk to the conference, and there are pictures of him. He would walk to the conference with Brennan. They'd be arm in arm. And it was always a sort of a funny picture because, as Professor Fisher, Marshall was a big guy. I think he was over 6'2". I mean, he was like really big, and he was in a big girth, and just everything about him was big. And Brennan, on the other hand, was a diminutive man. And so, they'd walk arm in arm, and it really was a sort of a funny sight. But even Brennan and Marshall didn't talk nearly as much as I would have imagined. And I don't recall Marshall, he was congenial, but no, I don't remember this. And Marshall also, there was one other striking thing about Marshall. He was very determined to be independent. So when we were there, I think most of the justices were part of what they called the pool. So when people would send in to petition to the Supreme Court, they would have one clerk who would write a memorandum for all of the justices who were part of the pool. Marshall did not allow us to be part of the pool. We had to write a memorandum about each case. And I think that the reason for that, correct me, I think that the reason for that was he just liked the idea of doing, things his way, his own judgment. He didn't want to be part of any grouping. So I don't remember him. I can't remember one single time when I saw him in a, sort of long discussion with anybody. I think he was very much of a loner. Is that what do you think?
Yeah, I think that's right. And it's also right that he was as close to Brennan as anybody. Their chambers happened to be side by side. And there was one, the clerks, to be honest, we work late at night, and you go back and forth in the chambers a lot. And Brennan had in his desk a set of notebooks, little teeny black notebooks, and not super small, but smaller than a legal pad or regular pad like this. they contain notes about, quite detailed notes about what had happened in every case. I think that somebody provided the authors of the Brethren access to those notebooks, which helps to explain some of the detail in the book. I had an intuition at the time, for which I had no direct evidence, that Marshall didn't like that. He was generally speaking hostile, not just to talking to reporters, but what he called making a record or building a record. Any written documentation of what had happened, he didn't like. And so there may have been some friction arising out of that. But there's one other thing, I just go back to one of your themes, is he's kind of a paradoxical person because he was so precise and powerful and analytically formidable as a lawyer. But he's also kind of a brawler, and he drank and he smoked and he gambled nobody else in the Supreme Court is like that. They're temperamentally totally different. So it would have been an awful long reach in terms of personality for him to hang out with any of the other justices. I actually remember the time that he was most disappointed with us. Remember my recollection, see what it matches yours, is after that initial awkward period, he took us out to lunch, kind of a late lunch, in some very scruffy restaurant. And it was early in the afternoon, and he ordered beer. And he asked, what do people order? And we ordered quite innocuous things. And none of us ordered any alcohol. And he went, he thought this was, oh God, we got another crop of nerds. The vibe. He was plainly disappointed. So anyway, it's partly a temperamental thing.
Yeah, imagine Thurgood Marshall with Lewis Powell.
Yeah.
I mean, or Berger. I mean, those folks just didn't, they wouldn't have fit so well. There was nobody even close to to him. I mean, he would tell off-color jokes. There was no telling. I mean, he would say all sorts of things. And, the others were, much more buttoned up, folk.
It's also the case, be blunt here, they're all wealthy, all the other justices. And he was not. He lived in a pretty modest house and went there for dinner once, there was a kind of a rec room downstairs, and it's just a different class from all the other justices.
Well, he was a regular person, they were real rich.
Yeah.
Given that you as law clerks kind of sometimes function as extensions of the justice, I was wondering, this sort of dovetails with the anecdote that Professor Fisher was saying, what was your sense of what he looked for when he was hiring his clerks?
You hit on another thing that of late I've been concerned with that actually. Or at least to me, it deserves attention. So, a number of years ago, there was a one-man play. Larry Fishburne played Thurgood Marshall. It's a great play. Great. I mean, Larry Fishburne had it down. I saw it in New York. The stage was just Thurgood Marshall, Larry Fishburne on stage, and they had a thing across the top, and it said Howard University Law School. Marshall was very proud of having gone to Howard University Law School and graduated #1 in his class at Howard University Law School. Thurgood Marshall never had a law clerk from Howard University Law School. Not one. Thurgood Marshall had no black clerks while he was a Court of Appeals judge. I have never come across a black person who worked for Thurgood Marshall in the Solicitor General's office, and given my interests, and just, I bet that I would have, had there been a black person who worked for Thurgood Marshall in the Solicitor General's office, just sociology being like sociology is. For the first 10 years that Thurgood Marshall was a Supreme Court justice, he did not have a black law clerk. His first black law clerk was his goddaughter, Karen Hasty Williams. After that, he had more black law clerks than the other justices, but that is a very low bar. He had very few. So my year, he had one. I was the only black law clerk at the Supreme Court that year. The year after me, he had none, and the year after me, there were no blacks at the Supreme Court law clerks. Very few. And I think it's an interesting issue. I mean, I think, for a variety of reasons, I think people haven't, much talked about it. But I think going forward, for people to really get a grip on an understanding, a deep understanding of Marshall and his times, it seems to me that that's an interesting issue. My sense, now, to contrast the race issue and the gender issue, Marshall had a substantial number of women law clerks, and I get the sense, actually, that he was much more inclined to be self-conscious in really insisting upon women law clerks than with respect to racial minority law clerks. Just sort of an interesting thing. What was he looking for? This gets to, Marshall was very old school, very old-fashioned. He, put a lot of store by grades. He put a lot of store by the prestige of the law school. He put a lot of store by a certain small number of judges who were people whose recommendations counted for him a lot. It was a very small group, very small. And frankly, I think that he, and by the way, I would say Brennan as well, could rightly be criticized for the decisions that they made. I think that, when people talk about in today's political world, when people talk about the limited base of liberalism, the strongly, maybe excessively elitist cast of liberalism. If you take a look, for instance, at the people who Byron White, chose as law clerks, or the people that William Rehnquist chose as law clerks, there were a bunch from the fanciest schools, but they also had people from the public universities and their home states, and more variety, interestingly enough, more diversity. Brennan and Marshall, very clear profile. I got in a beef with the justice about this once, and I asked him straight out. I said, Justice Marshall, why is it that virtually all of your law clerks are from Yale and from Harvard, but particularly from Harvard? He had a special thing for Harvard. And he looked me dead in the face, and without flinching, this was just the way he was. He said, what are universally viewed as the best law schools in the United States? You answer me that question, and you will have the answer to your question. And that's what he was. And he was, he was like that. Now, I think that, you know, there's something to be, you know, there's a story there, and there's more to be said about that. And I think that, you know, in any event, that's the way he was from my perception. What do you think? You were there.
Yeah, I agree with pretty much everything you said. I do think it's, as you make a judgment about him as a man, that not put a whole lot of weight on imperfections. So, yeah, he had fewer black law clerks than he could have agreed with that. On the other side of the ledger, he had way more women law clerks, as you pointed out, than any other justice. Brennan had zero.
Zero. Yeah.
Because he said women made him uncomfortable.
He hired one the year after he retired.
Now, there is this puzzle to which I do not know the answer about why so many of his law clerks become academics.
You mean Marshall?
Marshall.
Yeah.
It's, I think there are, the last I counted, there are 11 on the Harvard Law School faculty. It's just way more than any other justice ever. Now, I don't know how that happened, but relevant to what he was looking for. Although it would have to be quite mysterious how it worked out, because he did not interview law clerk candidates. He relied on other people's judgments. So he left out of the process one of the things by which he could have been making judgments. And so what happened was things came out of the blue. I remember I was working in the Court of Appeals, and a phone call came to his secretary and forwarded to me, and I picked up the phone, and there's this booming voice on the other that said, "Still want a job?" Yep. Okay. Wasn't a lot of circumstance.
Yes.
Given recent confirmation hearings, I'm curious about how the contentions played out in his and how he responded.
It was very straightforward. The segregationists tried to embarrass him, tried to slow it down, tried to do all they could to prevent him from, getting successfully ensconced at the Court of Appeals and the Supreme Court. The person who I remember, again, I'm from South Carolina, and so, Strom Thurmond, sort of stomach turning to see Strom Thurmond trying to, suggest that Thurgood Marshall, of all people, wasn't learned enough in constitutional law to, be a justice. Thurmond, Eastland, it was all, that's what it was. It was pretty straightforward. And there it was. It wasn't any more complicated than that. It was all about one thing, and one thing only. And he just, patiently sat and, parried the questions, and, frankly, compared to now, it was quick compared to now. But in its own time, it was highly unusual. And there's a guy, another Marshall clerk, Stephen Carter. Stephen Carter wrote a book called The Confirmation Mess, I think that's the name of it. And he says, you know, many people talk about the downward, you know, trajectory of confirmation hearings beginning with, you know, the Bork confirmation hearings. He says, no, you know, go back, you know, take a look at what, you know, happened with Marshall. And, but, you know, but that's what it was. Pretty straightforward. One last question. Yes, sir.
Thank you, Professor. I'm curious, how do you think Justice Marshall would view the evolution of and the current state of civil rights in the U.S. now?
Well, like I said before, you know, he had seen a lot in his own time. And he had seen a lot in his own time, and he had seen a lot of change in his own time. And my sense is that he would have, you know, sort of insisted that people take, you know, the long view. I think that he would have insisted people, you know, when people say, well, you know, things are so terrible, I think that his impulse would be to say, you know, well, okay, let's get some comparison building. Compared to what? Compared to 1940, compared to 1930, compared to 1950. I mean, you know, what we need to have some, if we're going to talk about it seriously, we need to have some baselines, we need to have, you know, let's have a comparative vision. So, you know, would he be happy? No, he would not be happy. I mean, I think, again, I've mentioned one of the things that was really deepest, one of his deepest commitments was, you know, had to do with capital punishment. And I think that he would be really quite sad about the fact that, at least formally speaking, the way he wanted to go has not been the way that society has gone, though it's, you know, one, you know, needs to mention that, you know, there has been a tremendous fall in actual carrying out of capital punishment, and he would be happy with that. But, you know, he would be sad by, you know, he would be saddened by the idea that, you know, our society is, you know, still embraces the proposition that it's permissible for the state to premeditatedly, you know, extinguish people's lives. So there, you know, there'd be things that he'd be sad about, but I think he would say it's a long distance run. Take your opportunities when they come. I think he would say to everyone, there is a struggle to be waged everywhere. He was not a person, for instance, who was insistent that every lawyer be a civil rights lawyer. He was, you know, very good friends with people who were, you know, big shot, big fat, you know, fat cat lawyers and firms. I think people, you know, different strokes for different folks. But I think his position was wherever you go, there's something that, you know, everybody can do. And I think that would have been his message. Listen, y'all, thanks for coming out, and thank you very much, Terry, for joining us.